Lecture 5, Classification of Offenses and Punishment. There are two basic types of law we'll talk about right now, criminal law and civil law. Criminal law, as the term implies, concerns itself with defining those specific acts and omissions or failures to act which constitute a crime in our society. The most common crimes are described and defined in the California Penal Code. However, you need to realize there are at least 40 other California code books that have listed crimes in them. Those can include the Vehicle Code, Education Code, Welfare and Institutions Code, Health and Safety Code, Fish and Gaming Code, Harbor Navigations Code, and Business Professions Code. The penalty for committing a crime which a criminal code section prohibits or not doing what it commands you to do is usually a fine or a jail term. Civil law has to do mostly with describing or establishing rules for various legal relationships, which are mostly business relationships, and other agreements. Civil law is describing the contents of a contract or the terms of a promissory note, known as a loan, are typical examples. Some of the codified civil law can be found in California code books such as the Code of Civil Procedure, Business and Professions Code, and the Welfare and Institutions Code. Most civil law, however, is found in published court cases. Violation of civil law, which is called a tort, are enforced differently than are violations of the criminal law. The major differences between criminal law and civil law. In criminal law, there must be criminal intent. The state is the prosecutor. Few complete settlements out of court. Judges usually review all plea bargaining agreements and any thing that's going through the court. Damages or fines go to the public treasury. Contributory negligence is not a defense, meaning that the victim did something to bring the crime upon themselves. Punishment is the objective of the judgment, and punishments or fines are limited by statute. Statutes have three things. They have what the description of the crime is, the intent in the act, and the last thing is it must describe a punishment. In civil law, there doesn't have to be intent to commit the act. The act could have been an accident. The victim or plaintiff is the prosecutor in the case, and most cases are settled out of court. Any damages that arise as a result of the case go to the victim. Contributory negligence is a good defense or mitigating factor. In other words, if you have a vehicular accident, two people come to an intersection, one person runs a stop sign and they're intoxicated. And they run the stop sign at a very slow rate of speed, but they still run the stop sign. The second person is going, let's say, 65 miles an hour in a 35 mile an hour zone. So they're going almost twice the speed limit. They're going twice the speed limit almost. And they would have contributed to the accident, even though the person who's intoxicated around the stop sign has liability. So in that sort of a case, because of the contributory negligence of the person who's driving fast, the jury could make a decision and say that, let's say it's $1 million suit, and the jury could say that the driver of the car that was speeding, they're the victim in the case, and although the defendant was drunk and ran a stop sign, that the victim of the accident contributed 60% of the negligence. So if they say 60%, it's a 60-40 split, that means a person who's suing for $1 million would only get $400,000. The objective of the judgment is to restore the victim to the original condition that they were in before the incident took place. That meant if you, in this situation, you were in an accident, you had to have surgery and rehabilitation, you lose work, you have emotional problems, all of these things would have to be taken care of by the damages assessed in the case. And there's no limit on damages. Classifications of crimes by seriousness. Mala and se. Mala and se are true crimes. Mala and se basically means bad in itself. Crimes that are bad in themselves. Murder, rape, assault. These are all crimes that we agree upon that they're bad and they need to be listed to control deviant behavior. It excludes crimes of moral turpitude because they vary from society to society. Those crimes are covered under the topic of mala prohibita. Mala prohibita means prohibited. They're bad because they're prohibited. These are regulatory crimes. Those are things like drugs, smoking, prostitution and gambling, sale of alcohol to minors, and traffic laws. Classification of offenses by purpose. Substantive law. Substantive laws, it basically tells you the law requires a person to do or not do something. An example would be, and these are what you normally would think about as violations of crimes. Entering a structure with intent to commit a theft or other felony is burglary. And so most criminal statutes are substantive law. Procedural law, however, tells how the law is to be carried out. It sets rules for making an arrest. For instance, a citizen cannot make an arrest unless on a misdemeanor crime unless it occurs in their presence. If an officer makes an arrest on a juvenile under 625 of the Welfare and Institutions Code, within 1 hour they must read that juvenile the Miranda warning. If a suspect is taken into custody and held in custody, they must go before a judge within 2 days, 2 business days, for a preliminary hearing. Persons are supposed to be allowed phone calls. They're supposed to be allowed to see their attorney or physician. These would be procedural laws, how to carry the law out. Classification of law by punishment. Most serious of crimes in California are felonies. Felonies are punishable by death, incarceration in state prison for more than 1 year, disqualification or removal from, or inability to run for office and or a fine, a political office, I mean. A misdemeanor, punishment of incarceration in county jail for less than 1 year and or a fine. A wobbler has a punishment that can be interpreted as a felony or a misdemeanor. An example, 261.5 of the Penal Code is statutory rape. This is where a person is convicted of having unlawful sex with someone under 18 years of age. Could be with consent. The punishment is 6 months, 18 months, or 24 months. Well, anything over a year would be in prison, and so the 18 months and 24 months qualified as a felony. But the 6-month option for sentencing qualifies it as a misdemeanor. Public offenses. Infractions are crimes that the only punishment is a fine. There's no right to a jury trial. There's no right to a public defender because you have no life or limb on the line. All you have is money on the line. And that's why when you have traffic court, for the most part, you don't see attorneys that show up except for celebrities to deal with those sorts of cases. Ordinances. Article 10 of the California Constitution only allows, Article 10 of the U.S. Constitution only allows the states to make laws, so cities and counties can only make public offenses. Usually the punishment for a public offense is a fine. It could be burning trash, or it could be having a car that's disabled in your front yard for longer than 72 hours. Classification of crimes by punishment. So before sentencing, a wobbler should be treated as a felony. This is because under laws of arrest, a felony, you have more power as a peace officer. The differences between the two, which is really covered in criminal procedures, is that on a felony, you can arrest for a felony if you have probable cause to believe a felony occurred and the person in front of you committed it. Now, it has a little catch at the end. Whether or not a felony actually occurred. This means that if you got probable cause, you see something as an officer, you think it's a felony, you make the arrest, turns out it's not an arrest, you don't have liability on that case. Example, officer's driving down the street, makes a minor traffic stop. When he walks up to the car, he sees a VIN tag removed from the windshield area of the vehicle, and he sees a VIN tag on the ground, looks like it's been removed. Well, that's a felony. Officer makes an arrest pursuant to that he's observed, and he searches the suspect under Schmelin in the right front pocket of the guy's pants. He's got an ounce of cocaine. The officer goes down and collects the VIN tag, takes to evidence. Later on, it's discovered it was not a VIN tag. It looks very much like one, but it was not a VIN tag. Not only is the officer vindicated in the arrest was good at the time. The felony that he found afterwards, the additional cocaine, is allowable because the officer had probable cause at the time to arrest for a felony that he believed occurred in his presence. The other thing is use of force. You could justify use of force on felonies more so than on misdemeanors. If somebody's resisting on a misdemeanor or runs, unless you're fast enough to catch them, gotta let them go pretty much if you can't catch them. On a felony, if the person is resisting, you can use more force than you would on a misdemeanor to take that person into custody. Again, it's got to be reasonable force. Getting back to the felony, the Wobbler real quick, who's going to make the final decision? It's going to be the district attorney. The district attorney is going to decide what's going to be charged, the misdemeanor section of that or the felony section of that. After a sentence has been passed, if you're charged with a felony and you get sentenced as a felony, there's restrictions. Felons can no longer be in possession of firearms. They don't have the right to vote anymore. They may be subject to probation or parole searches. And they may pose officer safety problems for us in the future. Final classification of the crime is not where the person's going to do their time, but it's where they're sentenced. An example I'll give you is a burglar is sentenced to prison for 3 years, and the judge decides that he's going to do what's called shock probation. Shock probation is where you send them for a few months to jail to get a taste of jail, and then you put them on formal probation. So the judge sentences them to 3 years, suspends 2.5, and gives the person mandatory probation and sentences them to 6 months in county jail. So here we have a felon doing time in county jail, because remember I told you the definition was on a felony, it's more than a year in state prison. On a misdemeanor, it's less than a year in county jail. Now, if this burglar does his 6 months, goes out on probation and violates probation, they could go back and do the rest of their time in state prison because they still have over 2 years to serve. Sentencing. I'm going to talk about indeterminate and determinate sentencing. California, we don't use indeterminate for the most part. We use determinate, but you need to know what both are. Indeterminate sentences are where the judge puts a lower and a higher end on the sentence. In other words, you have to serve at least, if you're given 5 to 10 years, you have to serve at least 5 years, but no more than 10 years. You could be released anywhere in between. Well, there's been a large cry from prisoner advocate groups and attorneys in that area who have lobbied to say that basically that's unfair because the punishment should be in the hands of the judges. California pretty much looks at determinate sentencing, and determinate sentencing is where they give 3 possible sentences. The example I'm giving here is 2, 3, or 4 years. If the punishment is 2, 3, or 4 years, the judge can pick the middle punishment without justification. However, if the lower or higher punishment is picked, they must state in writing what the justification is. If the judge decides to cut somebody some slack and give them less time, or give them more time because of mitigating circumstances, the person has it coming, they were very violent in the commission of the crime, they can do that. They just need to justify it. Enhancements are basically where a person can get additional time in in addition to the original time that's prescribed on a crime. Examples could be prior prison terms for serious felonies. The three strikes crime. The first time you get your basic punishment. The second time it's two times the amount of punishment, and the third time it's 25 years to life. Example of one of the few indeterminate sentences that we use. Committing a crime while armed with a firearm or while using a firearm, that's 10, 20, or life. During a felony, takes, damages, or destroys property over $50,000, or a person who, while committing a felony, personally and intentionally inflicts great bodily injury. They get additional time for these sorts of enhancements. Additional enhancements or sentences could be that no probation or suspended sentences for felonies where firearms are used, or a limit on time a person can spend on enhancements. Also, good time credit, whether or not a person can get parole. Let's talk about some other things. Consecutive sentencing and concurrent sentencing. Consecutive sentencing is where a person serves their terms back to back. Example, person does a robbery, and during the robbery, they hit a clerk, and it causes a serious injury. They take another clerk hostage and release her sometime later. So they take her car. So you have a robbery, a felony assault, and an auto theft. Now let's just say that the sentencing for each one of those separately is 5 years each to make it easy. If the person serves consecutive sentences, they're going to go back to back, so they're going to serve a total of 5 years each, 3 crimes, 3 times 5, 15 years. On concurrent sentencing, it means that the date of service for that punishment starts at the same time for all 3 sentences, meaning that they'll serve a total of 5 years. They all run together. Okay, they run together. We're going to talk a little bit about lesser offenses, lesser and included offenses. Lesser included offenses. In California, there are several offenses, the commission of which necessarily includes other lesser offenses. However, before a lesser offense may be said to constitute a necessary part of a greater offense, all of the legal elements of the lesser offense must be included. They must be present. For example, every battery, punching someone, which is a misdemeanor, includes an assault, which means putting a person in fear of assault and having the ability to carry that out. But battery is a greater of the 2 offenses. Penal Code Section 1159 states that the jury or the judge, if a jury trial is waived, may find the defendant guilty of any offense, the commission of which is necessarily included in that with which he is charged or she is charged, or of an attempt to commit that offense. So I'm going to give you an example here. Petty theft, the taking of personal property of another without their permission, with intent to permanently describe the owner. Now, if you look at that right there, that's petty theft. If I add the next element, when the value is over $400, it makes it grand theft. So in every grand theft, there is a petty theft. Now, definition of grand theft person: the taking of the personal property of another without their permission, with intent to permanently deprive the owner when the property is taken from the person of another. Now, if we add one more element, by use of force or fear, it becomes robbery. Changes the outcome of the case. Lesser degrees of crimes. Burglary first degree is the same as burglary second degree, except it includes an element stipulating the location of the occurrence be an inhabited dwelling. So first degree burglary means that it must be a dwelling that's inhabited. Second degree burglary could include something like breaking into your car. It's not really inhabited. It's not a dwelling, a place that someone normally would live. Victimless crimes, crimes that have no victim that suffer from theft or damage. The list includes prostitution, drugs, gambling, pornography, abortion, or public intoxication. Key terms for this lecture. You should be reading your book, listening to this lecture, and you should be able to define the following terms. Criminal law and civil law, and what's the difference between the two. Mala and se crimes, mala prohibita crimes, the difference between the two. Substantive law and procedural law, define them and be able to compare and contrast them. What's the difference? Felony misdemeanors, wobblers, infractions, should know what those all are and their punishments. Ordinances, who makes those and their punishments. Should know what parole is. Should know what consecutive and concurrent sentencing are and the difference. What are enhancements? What are indeterminate and determinate sentences? What are degrees of crimes? And what are lesser offenses and victimless crimes? This is the end of Lecture 5.
Way cool!